As with a lot of our webinars, this is meant to be interactive. So if you have any questions, you can submit them to the Q&A function if you're watching on Zoom, of course, and I will be able to see those come up. So please, if you have any, feel free to submit them as I'm going through. And then we have sent out a couple of materials to you if you signed up using your email. First and foremost is our feedback form. So we obviously love feedback. It helps us always, come up with interesting topics, but it also has a place for you to let us know if you want us to reach out to you to set up an initial consultation with one of our attorneys. Those are scheduled for 2 hours. They are complimentary, so it doesn't cost you anything to come in and talk to us. But if you'd like us to reach out to you to set something up, that feedback form is really a great way to do that. Of course, you can always reach out to us as well if that's what you would prefer. But that if you want us to reach out to you, that's the form we need you to fill out. And then we are also sending out our document finder form, which is essentially a helpful chart that you can say, like, here's where my powers of attorney are kept, or here's where my trust or my will is kept in the home, so that your family members can find your documents if they don't have copies already. I always encourage people to have copies to either accessible to the important people in the plan, the people who are going to need to administer it or make decisions. But if you're not comfortable doing that, they do need to know where to look for those documents, because they don't do a whole lot of good if your will is locked away and nobody can find it, right? With today's topic being on blended families, we do have some upcoming topics as well if you're interested in those. So this webinar obviously is in the evening, but normally we do them at noon. So next week, we're going to be talking about minimizing stress for your family members by doing proper estate planning and making sure that you have good planning in place for them to step in for you and take care of things. And then the week after that, we're actually talking on a much more basic level, kind of estate planning 101, if you will, the tools that you should have in every estate plan, really regardless of what type of planning you're doing. So if you're looking for a very ground level kind of maybe basic understanding of just what it is that you need, that can be a really good one too. So again, keep an eye out for that feedback form and that document finder form, and please submit questions if you have any. But to get started, when we're talking about planning for blended families, I think a lot of people maybe don't understand what can really go wrong or what can happen when you don't do any planning, or if you're just kind of relying on default rules. Because a lot of times the default rules are going to be very different than what maybe your intent is. And now intent varies on how you want things divided up, if you have concerns about remarriage of anybody, but you want to know what those defaults are so that you can either opt into them or opt out, as the case may be. And as an estate planning attorney, as an attorney in general, I almost never recommend relying on the default statutes alone, because they can really not be the right fit for everybody. But when we're talking about the default rules, what I mean by that is whether or not you actually have an estate plan in place, whether you've done a will or you've signed a trust or anything like that in the past. If you haven't done those things and you have no planning in place at all, there are what are called the intestate rules of succession. And that's essentially like the state of Wisconsin wrote a will for everybody if they don't have one, so that we know how their estate should be divided up if assets are going through probate. And when it's a non-blended family, a first marriage, all joint kids, it's relatively straightforward of what happens in those circumstances. But with blended families, things become a lot more complicated because there's different amounts that might be going to the surviving spouse or directly to the children that are the biological or adopted children of that deceased spouse, right? So it's not, if your assumption is that everything goes to the surviving spouse, that may not be the case depending on how you have your assets set up. Now, another concern can be how, whether or not you're using those intestate rules of succession, is how you have assets titled and also how you have them designated through beneficiary designations. So maybe you do want to split assets up on the first death or protect assets for your kids from a subsequent marriage of a surviving spouse. You want to protect that for them. Where that can go wrong, of course, is if you have everything, in your names together, jointly titled, just as joint owners on things. When that happens on an account, that automatically goes to the surviving spouse, right? Or to the surviving owner. So if you want to split things up differently than how they would go through that joint ownership with right of survivorship, you might want to plan differently than just having everything jointly titled. That can also create another issue too, if you're trying to keep things separate for marital property reasons, if you had a prenup signed before marriage. But it can also cause a lot of problems for estate planning, because if I'm on an account as a joint owner with somebody, a lot of times what that means is it just becomes mine if that other person passes away. You also need to be very aware of what beneficiaries you have on accounts, what those designations are, because if that is different than maybe what your will says, that might mean that your will actually isn't followed, because in order for a will to be followed, those assets have to go through probate. If you have beneficiary designations, those assets go directly to those people. So a lot of people mistakenly believe that, well, my will says this, so this is what should happen. Well, if those assets go through probate, that's the case. But if my will says that my wife gets 50% of the estate and my kids from a previous marriage get 25% each, then, and my retirement account or my bank accounts that I have separately, life insurance, whatever it might be, if that just says all to the surviving spouse, right, or maybe all to the kids, as the case may be, that 50% to the surviving spouse, 25% to each of those kids, maybe isn't quite what actually happens, because those beneficiary designations are going to override what the will says, because it's not going to go through probate then, those assets with those designations. So my point with that is not to avoid using a will or to avoid using beneficiary designations. My point is to make sure that you're coordinating your assets properly so that whatever your intent actually is what happens. That's true of estate planning across the board, not just for blended families, but I think especially with blended families, that's where things can be a lot more concerning if the results that you intended isn't what actually happens. Because a lot of times with blended families, there might be added stressors in there, especially amongst maybe step siblings, where conflict could arise if what they see in the will isn't what happens, right? That's where you're adding potential conflict in that could be avoided otherwise. Now, you can't avoid all conflict, I understand that, but it doesn't help when the end result is different than the clear intent was in the will or in the trust. So if you have a will, you want to make sure that certain things are going through probate to follow that will. If you have a trust, you want to make sure that you worked with somebody to properly title things in the name of that trust, or at least designate things to that trust. So in estate planning, that's what we call funding the plan, making sure that the assets are aligned properly with whatever that is. So if, whether you have no planning in place at all, and you have the intestate rules of succession where it's maybe a little different than you might want, or you have things that just completely go around the planning you've done and don't match the overall intent, you have to be very aware of how you're designating these things, what these rules are, and what the actual result would be with how you have things set up, so that if your intent is to split things a certain way, you actually have that occur, rather than just think that it's right or hope that it happens or assume that people will share it the way you want them to, right? So those default rules, especially for blended families, and that intestate rule of succession can be a huge concern if you don't know what those are, or if it's different than what your intent would be. Maybe you do want the surviving spouse to actually have the right to, benefit from all of your property until their death, but you want to make sure that those assets go, at least some of those assets go to your kids, and that they can't be disinherited, or it can't all go to a new spouse, right? There might be, you want to provide support for that spouse, but not, you also want to make sure that your children benefit in the long run. And that can be a huge concern if you haven't done prospective planning around that, or talk to somebody who can, set up that type of planning for you, because, the concern is often not so much that the surviving spouse isn't trustworthy. It's just that a lot of times when people get remarried, they say, all right, everything goes to my surviving spouse. It's probably the most common estate plan in the world, right? So you want to make sure that if you wouldn't want that to even accidentally happen, that you have something in place to prevent that. So I think the considerations on that you want to have when you're deciding, do I divide certain things out on the first death where maybe my spouse can benefit from it, but then ultimately that a pot of money is going to go to my kids. That surviving spouse can't change it, but they can at least get the benefit of it during lifetime. Maybe one of the kids is in charge of that money for them so that there's somebody on your side looking over things for them. That type of planning can be great for blended families, because then your intended result is what happens. You're not hoping for the best, or, especially where spouses have different, maybe different end results. And this happens a lot too, where they might say, well, if I die, I want my property to go, 80% to my kids, 20% to your kids. But then the other spouse says, well, I want it to be 50-50, right, between all of our kids, for each side. But if it says on my death, X, Y, and Z happens, and on your death, A, B, C happens, the concern you're going to run into is now your plan is contingent on who dies last. And that can be a huge problem if your wills don't match, for example, or if you have, a joint trust that says different things on each death and doesn't separate property out. So when you're doing this type of planning, the very important thing to consider is if you do need to divide things up on that first death so that your property, your intended property, follows your intended path, but maybe the surviving spouse's property goes the way they would want, you want to make sure that it just doesn't depend on who dies first what happens, because then you're just leaving things up to chance in terms of what that result is. Now, if it's the same results no matter who passes second, that might be a different story, but even then there can be reasons to separate things out if you would want to restrict the ability for that surviving spouse to change things. And again, I'm not saying that your surviving spouses are all going to disinherit your kids right away, but I think the concern here is getting guaranteed results versus leaving things up to chance. Even if I trust somebody wholeheartedly, I might want to make sure that for my own comfort, that my kids get something, that they're not going to be disinherited, that nothing can happen that's going to change that if they, don't want it to. So the considerations, though, that I was getting at earlier of what you would want to think about in terms of, how much you might separate out on the first death, or if you do this planning at all, is first and foremost, are there remarriage concerns? Because I've had clients who say, we've been married for, 40 years, even though this is a second marriage, but we're not concerned about it. It's basically all of ours jointly. That's how we treat things. If that's the case, maybe it doesn't make sense to separate things out on that first death where it's, in the surviving spouse's pot of money and the family's pot of money. It might not make sense to do that if both spouses are okay with avoiding it. You just have to understand, though, that if everything goes to a surviving spouse, that they might have the ability to change certain things and change beneficiaries, whether it's changing percentages or changing full on who the beneficiaries are. Those are things that you just have to be aware of. And if you're comfortable with that, then that's okay, as long as that's your intent. If it's primarily making sure flexibility is key, that you have that surviving spouse has very few restrictions on how they use things, and you don't have concerns about them changing beneficiaries, for some people that works great. But if you do have those concerns, you still would want to consider, should I change or separate things out so that my surviving spouse can't change certain things about the kind of siphoned off pot of money. And again, one thing to remember with that separate family side of things doesn't necessarily mean that the survivor doesn't have benefits from it, isn't getting income from it. It just means that they may not be able to change where it goes when they pass away, that part's locked in, depending on how it's written, of course. So the considerations and what you might be thinking about when you're having that discussion is the length of the marriage, which I sort of mentioned with my example. If somebody's been married for 50 years, even if it's a second marriage, is that really a concern of theirs? Maybe they have actually mostly joint kids. Maybe one child is from a prior marriage, or only a couple of the many kids are. It just depends. The number of joint kids makes a difference too. I mean, are all of the kids joint, or not all of them, because that would be a blended family? Are most of the kids joint? Are none of the kids joint kids? Are they all from prior relationships and none of them are joint children? That's going to be probably a lot different in terms of what you might want to be considering and what's fair versus what's equal when you're talking about dividing assets, versus if most of the kids are joint and maybe one is from a prior relationship. And that fair and equal consideration is also very important here. Have you and your spouse talked about, maybe inequities in terms of what you came into the relationship with? I mean, a lot of times when people have prenups, they think of those things of like, well, here's what happens if we get divorced. But, maybe there was a huge disparity between, I came into the relationship with, $1 billion, and I want to make sure that my kids get most of it, and you came into the relationship with $1 million. Is that splitting all of those assets equally if, amongst all of the kids, if they're not joint, is that fair? It depends. I mean, it's ultimately what's fair is what you want it to be. But equal, dividing everything equally is not always what's fair. We talk about that a lot with like business clients too, when they're inheriting businesses or transitioning businesses to the next generation. But it, of course, goes across the board of maybe equal isn't what your intent is. Maybe that's not what's fair in your circumstance. And you just have to have that discussion. I'm not saying there's a right or wrong way to look at that. You just have to have the discussion and be on the same page. Another thing with the kids is, what's the age difference, I think, between the kids? Are they all adults? Are there some that are minors, some that are adults? Is there a pretty big age gap there? Because then you're not only going to need to consider what's fair and what's equal, you might also have to consider making sure that those younger kids have some support that gets them up to that same point of the older kids, right? The adult children, get them through high school at least. Do you want to pay for their college? Does that mean they end up getting a little bit more money than those older kids to get them to that same point? Those are things you can consider as well. With minor children in a blended family, this is often overlooked, I think, is who are the guardians for those kids if you pass away. Now, most of the time it's the other parent, and I mean biological parent, not necessarily like step parent, but maybe that parent's passed away. Maybe it's just you. Do you want it to be your spouse? Do you want it to be a family member? Those are things you're going to have to discuss. So different guardians might be the case for the different kids. And I think that's just, again, there's no right or wrong way to do that. You just need to make sure you're having these discussions because it can be a sticking point for people. Now, with blended families where, let's say, the spouses are older, maybe they're more concerned about going into care at some point here, or all their kids are adult, the supporting a minor child isn't an issue anymore. It's just making sure that your planning is what your intended result is what happens. When it comes to long-term care concerns, I think with blended families, people overlook some important considerations with how they're setting up that planning. They might think, well, this is a later in life marriage. Our kids don't really know each other, so they're not, we came in, we're both pretty well supported ourselves. So we're just going to say on our death, our assets go mostly to our kids rather than to a spouse. A lot of people have that goal, especially for those later in life marriages. The problem can be, though, is if there are care needs or care concerns in terms of like nursing home expenses or assisted living expenses, you might have concerns about, well, what happens if that surviving spouse would need Medicaid assistance? And so Medicaid in Wisconsin says that you can't gift things away if, in the 5 years preceding your application for care. So that's not 5 years before you go into a facility, it's 5 years from the application date. But we also have what's called a divestment by death rule in Wisconsin, which means you cannot skip your surviving spouse. You can't go directly to the next generation. So where that can cause an issue is if your surviving spouse is on Medicaid in a facility and then you pass away and your estate plan says everything goes to my kids or most of it goes to my kids. Well, if that surviving spouse is on Medicaid, that could kick that surviving spouse off. They might lose access to those benefits for a period of time, depending on other planning that you've done. So there are things that you can do, arguments that you can make if there was like marital property agreements in place on the death side of things, not on what's available while you're both alive. But on the death side of things, you can actually make an argument there. But maybe you don't have a marital property agreement. Maybe you don't have a prenup in place or never got one. And so you need to be very careful of, this seems fair, we both agreed on this. But if you skip that surviving spouse without other planning in place, there can be a lot of problems created for that surviving spouse. And it's almost certainly never anybody's intent to say, well, if my spouse gets kicked off of Medicaid, then so be it, right? That's not anybody's goal. So, making sure you have good marital property agreements in place that show what is marital versus separate property is very important. Making sure that you might have some planning in place if it's your goal to provide support for that spouse, but you wouldn't want to necessarily kick them off of Medicaid, or you wouldn't want it all to be eaten up by their care, right? There's planning you can do there to protect some assets on the death of the first spouse as well. Planning that you can get in place that makes sure that, well, my surviving spouse can still use this, can still access this during their lifetime. But my kids are going to be in charge of it. And if there's money left over when that spouse passes away, then everything goes to that surviving, or to that first side of the family. So there's planning that you can do to protect assets from care in a blended family situation and still make sure that your intent, like the ultimate result of where things go, make sure that that happens as well. You can definitely have the best of both worlds here. There's always going to be drawbacks to any planning, right? There's pluses and minuses. So in the example I gave on that Medicaid concern, well, if it goes to that protected side of things for that surviving spouse, but then ultimately goes to the kids, that means the kids might not get things right away, right? That's the downside. But maybe it is something that they'd be okay having be available for their surviving step parent, making sure that they're getting good quality of care. I've also had clients who say, look, if it happens, it's a risk. And if that's the case, you just have to be aware that, okay, if your goal here is to make sure that the kids still get things right away, that they don't have to wait for things, there could be some risks. And there could be Medicaid issues if that surviving spouse would need care. So blended family concerns, people often think about them from we just want to make sure things go where we want them to go standpoint. That is obviously a big part of it, because the default rules under the intestate rules for succession in Wisconsin might not match your intent. Your beneficiary designations, your how you have things titled might disrupt your intent, not go the way you want them to. But blended family concerns can extend to beyond that initial just separating of the assets. Are there concerns about care? Do you have equal assets for care or equal resources? Do you want to still provide for that surviving spouse, but then just ultimately guarantee things go where you want? There's a lot of things you can do to guarantee those end results while still providing for somebody. But again, the downside could be they wait a little longer. Now, I don't think that's a significant downside. I think it's just a potential downside depending on how you're looking at it. So I'm not seeing any questions. But one last thing I want to touch on, again, if you do have questions, please feel free to submit them. One last thing I do want to touch on with blended family considerations is when you're looking at what type of document you're using for your estate plan, it can be a big factor, especially in blended family situations. So you can pass your estate plan through probate using a will, or you can have things avoid probate with a trust. Now, what kind of trust you use is going to depend on your situation. But trust planning is a great way to avoid probate, but still have a plan in place. Will planning can be great plans, but they do require probate. So you just have to look at what's best for you, what your attorney would recommend. But with blended families, one downside that you'll hear a lot that people will mention about probate is that it is potentially public, right? I'm not saying they broadcast these things, but you can look up records about things. And maybe you're disinheriting somebody, or maybe things aren't equal, right, between all of the kids. And you don't want them all to know what the other beneficiaries are getting. You're trying to keep that conflict at a minimum. And with a will, the downside there is that they could figure that out. They can receive a copy of it. It is, public. They can look up records. So if you want to keep things separate from, or not, private, so that maybe each beneficiary can understand what they're getting, but it doesn't have the right or access to the other beneficiary's information, trust can be a much better tool for that, because you can dictate who's allowed to receive certain information. Beneficiaries might be entitled to their share only in terms of what it is and how much it is, and not know who all of the other beneficiaries are. So trust planning can provide a lot more flexibility for blended families when you're looking at privacy in particular, but it also provides a lot more flexibility for that separation on the first death that I was talking about, where some things go through, go to that survivor directly or to the survivor's side of things, so that they, it's their money, they can use it, they can change where it goes. And then some things go to that family side of things, where maybe they get the benefit of it, but they can't change a lot about it. So you can do that planning in a will and in a trust. But when you have those types of separations occurring, where something's being held in trust for the next generation, even if the current spouse is a beneficiary of it, if you're doing that through a court, that can require a bit more oversight. It's more of a hassle to set up and create that way than it would be with a trust that there's no court involvement in its administration. So when you're trying to do that, what's called like survivor's trust planning, or survivor's side of things planning, and then a family trust, which is that pot of money that eventually is going down to the beneficiaries that the first spouse intended it to go to. That can be more administrative and burdensome work doing that through probate, not just for the attorney, but for the trustee of that. They might have to file accountings with the court. They might have to show how the money is being spent, and that can require a lot more oversight and expense than if that's being done through trust-based planning. So it's not very common that you'll see that done through a will anymore, just because of that added administrative burden and expense. But it's not to say you couldn't. It's just probably not recommended. Again, I'm not seeing any questions. I'm almost out of time here. I just want to touch base on a couple of quick things, or remind you of a couple of quick things that I said at the beginning of this. And that's to keep an eye out for that feedback form. Again, our initial consultations are complimentary. Doesn't cost people anything to come in and talk to us initially. We want to be able to sit down and give you a good recommendation. We do ask for quite a bit of information when you come in, but that really helps us give a good recommendation to you. And we schedule those for about 2 hours, just to give us plenty of time to sit down and talk through things and really give you a good recommendation. It's hard to do that in 30 minutes. But we're also going to be sending out that document finder form for you as well. Next week at noon on Wednesday, we're going to be doing our next webinar, and that is again on minimizing stress through your estate planning for your family, really focusing on what makes things easier for them, takes the stress away, certain decisions away that they might otherwise have to make, right? And then the next week, we're going to be talking, I touched on it a little bit, but on a much more in-depth level on the difference between like a will or a trust, and what types of documents you should have, regardless of whether you're using a will or a trust to pass those assets. So I hope you all enjoyed this topic. It can be a really interesting one these days, because there are a lot more blended families than there have been in the past. It's much more common. And so it's becoming more common that we see it as well. I hope you have a good rest of your day and enjoy what remains of summer. I think we have 3 days left. So enjoy the nice weather, and I hope to see you